Hello again, everyone. Welcome back to part 2 on our lecture on risk management issues regarding the sports industry. In part 1, we talked about premise liability, what duties you owe a business invitee once they enter your facility, and about Fourth Amendment issues, pat downs. Can you search somebody as a condition to entering your facility, your venue, your arena? I had you read 2 cases. Sheehan versus the 49ers and Johnston versus Tampa Bay Buccaneers. From those cases, you can gather information where you can turn it and advise your client properly on the law. Part 2, we're going to talk about alcohol and injuries due to alcohol. You have a venue, you have a facility, there's drinking, there's alcohol involved. And when there's alcohol involved, there are injuries. All right. So in most jurisdictions, these laws are known as dram shop laws. And what dram shop laws state specifically is that you, as the venue, if you're commercially serving alcohol to minors or visibly intoxicated persons, you are responsible and are liable for any injuries that they may incur or any subsequent injuries to third parties. All right, so you as the venue, if you're serving alcohol commercially, if you're selling it to a visibly intoxicated person, and that person gets hurt, you are liable. Also, if that person leaves your facility, drives down the road, and hits somebody else, you are responsible and you are liable for the injuries to that person also. Okay, so it's a very with proximate cause issues. I mean, you were the proximate cause of the injury to that third party. So you got to be very careful. If that intoxicated person leaves your facility and injures somebody out there in the world, never even came to the game, never even watches the sport, doesn't matter, you are liable. All right? And take this a step further. You as a facility have a duty to protect the public from physical harm to third persons. That even means if under the Berman versus University of Notre Dame case, that means, let's say you're serving alcohol, that person leaves your facility, is in your parking lot, and gets into a fist fight with somebody. All right, you didn't cause the fight, you didn't have anything to do with the fight, but no worries, under the dram shop laws, even this criminal context, you are responsible for the injuries to the third party. So under tort theories and under criminal theories, under dram shop laws, you can be responsible or liable for injuries to third persons who are harmed by someone that you served alcohol to who was visibly intoxicated. All right, so even in the criminal context, so just be careful. You need to advise your client, your facility, your arena, your venue properly. All right, the lead case on this, the landmark case, is Verney versus Aramark. All right, it was involving my New York Giants. And if you guys read the case, there's a series of facts in this case. The young man showed up at the game at approximately 10:30 in the morning. Was drinking in the parking lot. Had a few drinks while he was out in the parking lot, entered the facility. While at the facility, he had a few more beers, was drinking most of the first half. At the halftime, he decided to go out to the Spirals. Everyone knows what the Spirals are at the stadium. While on his way to the Spirals, he bought more beer. And he stopped at one of the local kiosks and bought more beer. And then walked approximately 50 to 75 feet to the Spiral with 4 to 6 beers. There's some fact dispute on how many beers he actually had. And gave them to his sister-in-law, his brother, and his friends. All right, and actually had 1 or 2 himself. All right, so he bought the beer at the kiosk. The question becomes, was he visibly intoxicated at that time? He subsequently left the stadium, left the stadium early before the game left. Went to a couple local establishments, and around 6:30 that evening, was leaving one of those establishments, crossed the median, or the neutral ground as I call it in New Orleans. Went over the neutral ground, hit a car head on, injuring the mother and the young daughter who was sitting in the back. The young daughter was turned out to be a quadriplegic as a result of the accident. This was litigated. It took many, many years to get to a jury. After the trial, the jury came back with an initial approximately $135 million verdict for both the mother and the young child. That's huge. All right, so based on this verdict alone, you need to advise your client, if they are serving alcohol, of what the duties and what the responsibilities that you have are to both your patrons and to anyone they may hurt after they leave your establishment. The case was subsequently overturned on appeal and subsequently reached a settlement amount for a lot less than $135 million. But nevertheless, you need to be aware of this case, and you need to know how to advise your client properly. Within the case itself, there were a battle of experts. The experts talked about training of your employees, your alcohol servers, your cashiers, your alcohol management team. And so either be tips trained or team trained. Two different trainings that are out there. And the experts in this case said, if your employees are trained properly, they will not serve a visibly intoxicated person. They have 100% rate of not serving those who have a 0.10 alcohol level or more. All right, so my advice, and what I advise my clients on, is to make sure that everyone is tips trained or team trained. All right, there's two different services out there that can train your employees. Take it seriously. Make sure that they are trained properly, and also once they are trained, make sure that you have people out there monitoring it. Quick story: when Giant Stadium opened up, or the New Meadowlands Stadium opened up, there were secret shoppers the first day, and within 10 minutes of the game opening up, there were already 3 violations. Those violations meaning they served a patron more than 2 beers, they didn't check IDs, somebody was visibly intoxicated, they came in from the parking lot, they were visibly intoxicated, and they were served. All right. Nevertheless, that person needs to be taken out and retrained. So, the point of Ernie versus Aramark, the point of reading this case, is to highlight the significance of the liability that your facility will have when it comes to both injuries on your property and injuries that can occur off your property. All right. So you need to develop an alcohol management policy for both tailgating and for actual service within your facility. All right, you need to develop these policies. I mean, are you going to allow tailgating? Are you going to allow tailgating before the game, after the game? How long before the game? How long after the game? Are you going to monitor it? If you see somebody who is visibly intoxicated, are you going to make sure that they're not the ones driving? That there's a designated driver for a tailgating party, that kind of thing. What are your policies going to be? And also, what are your policies for your servers? I mean, is everybody going to be tips trained? Are they going to be team trained? If they are, what if they violate the policy? Are they retrained or are they fired on the spot? What was it due to the significance? Who are you going to train? Are you going to train just your servers? Are you going to train your servers and your cashiers? Are you going to train your your servers, your cashiers, and your alcohol enforcement people? Or are you going to train everybody? I mean, I'm a big advocate of training everybody. Might as well. The training is expensive, but it's a lot cheaper than a $135 million verdict. All right, I'm a big advocate on training everybody. If anybody Manager, housekeeper sees somebody who's visibly intoxicated, walking up, buying a beer, they have to reach out and tell somebody. Can't do it. Okay? Enforce your policies fairly, consistently. All right? Just because, it's a friend of a friend, no beer. Too bad. Start a designated driver incentive program. All right? Those work. Educate your concessionaires. I mean, you're maybe the one who has the liquor license, but it's your concessionaires who are serving. You need to work with them to make sure that all their employees are tips trained, or all their employees are team trained. All right, and not taking big tips. We'll let things slide. No, I mean, you need to make sure that your concessionaire enforces your rules and your policies regarding alcohol management. Also, educate the public. Educate the public. Let them know that hey, we're all here. We're here for fun. It's a game. It's an event. We're all here to have a good time, but we can't have anybody leaving this facility and hurting anybody else. All right. We also need to know that there is liability for injuries due to projectiles. All right. So baseballs coming off a bat, hitting somebody in the stands. Bats coming out of a hand, hitting somebody. Soccer balls flying off the pitch. So you're, as a facility, or you as a team, are responsible and are liable for projectiles. However, there is a limited duty rule. All right, you're still usually not liable for injuries for certain projectiles. All right, if it's in the course of business, we all been to a baseball game and know that on the ticket it says, not liable for foul balls. Keep your eyes out for foul balls. So there is a limited duty rule out there for projectiles, baseballs, bats that come off the hand. But it's not for everything. All right, if there was a case not too long ago where they were using maple wood to make bats. Now, maple wood is a lot softer. It's not as strong. All right, and somebody was injured due to a maple bat splintering and then flying into the stands. Well, did they assume that risk? All right. If you're sitting behind the netting at a baseball field and the ball somehow gets through and you're injured, did you assume that risk? Is the facility entitled to the limited duty rule? Depends on the jurisdiction. You just need to be aware that their fans and patrons could be injured at your stadium due to projectiles, and based on the circumstances, it may fall under the limited duty rule. It may not. All right. I think I had you read the case in the book, Edwards versus City versus Albuquerque. It kind of lays out the groundwork for the limited duty rule. There's also a good case out there called versus Global Spectrum. Sciarrotta. I'm Italian too. So those cases are great when it comes to defining or telling you about the limited duty rule and what the scope of the limited duty rule is about. Okay, but also be aware that there is a counter to the limited duty rule called the distraction doctrine. All right, so the distraction doctrine holds that a facility in a stadium can be liable for just when there are distractions at the stadium. So, all right, put it in context. At a baseball game, if you're not sitting behind the netting and a foul ball comes into the stands and you get hit, under the limited duty rule, more than likely the team is protected from liability, or the facility is protected from liability. However, if you have mascots who are walking around and distracting the patrons, distracting the fans from the game, and these mascots are coming around passing out t-shirts, passing out coupons, giving out free hot dogs, whatever it is, and if this is a distraction from the game, the team may now may have liability now because they're the one that caused the distraction. All right, so the limited duty rule during the course of the game, and somebody gets hurt with a foul ball, the facility more than likely will be protected. But if you have these distractions, maybe not. A lot of the ballparks now have picnic areas, where you're sitting away from you're not looking at the field. Ball comes in, somebody gets hurt, somebody gets hit and hurt. Were they distracted? Were they not? Should they have been paying attention? I mean, liability may fall upon the facility. You just need to be aware of these doctrines and advise your clients properly. Also, getting back to the Fourth Amendment, facilities could be responsible and may be responsible when their security uses unreasonable or excessive force in having a patron leave. So let's say there's a fight, or there's an unruly patron who's been drinking too much, or just an unruly patron who hasn't been drinking too much, and your security officers, or your security officers, use unreasonable or excessive force to remove that patron or remove that fan, you may be liable. You also may be liable for an unlawful arrest. All right. Many times in counseling facilities, what do we do about our security guards? I mean, they're overzealous. Well, train them. All right. Tell them to the last resort that you use force to have somebody leave. You use other methods up until force. You do everything possible to have this patron leave without using force, and never ever use unreasonable or excessive force. I know it's a lot easier to say, especially with everything going on in this climate right now. There's a lot of excessive force issues being talked about, Ferguson and whatnot. But you need to do your best to train your security staff on what is an unlawful arrest and what is the amount of force that it can be used in having a patron, in removing a patron from your facility. All right. Unreasonable, excessive force. The standard is objective. What is reasonable, what is not reasonable, is going to depend on the facts. I mean, was the person carrying a gun? Was he carrying a knife? Was he swinging at the officers, at the security officers? Or was he just mouthing off? If the person's just mouthing off and calling names and the security guard slaps him around, well, that's excessive. That's unreasonable. But if the person's carrying a gun and threatening himself, or threatening somebody else, or threatening the officers, there may be force that needs to be used. All right, it's measured under the reasonableness of the officer's conduct at the time of the incident. All right, it's very fact specific. All right, so I always advise my facilities to report. All right, get witness reports, get names of witnesses, get addresses of witnesses, telephone numbers of witnesses, and document everything. All right, so especially if the officer was acting reasonable, and the patron was unreasonable. All right, so get all the information that you possibly can and to get it documented. Unlawful arrest, the standard is, was there probable cause for arrest at the time of the occurrence? All right. Again, very subjective. Was there probable cause? Again, document. Get witness statements, get witness information, so you can have a file. So if anything does happen down the road, you get sued for unlawful arrest, you will have everything documented in your file, and you can have the witnesses come in and testify if need be. Same thing with First Amendment issues. All right, everybody who comes to your stadium, if there's state action, everybody has a First Amendment right. All right, they have a right to free speech. Not too long ago, the Yankees were sued over ejecting a fan who would not get up and sing God Bless America. Yankee security went and ejected this man roughly, with force, for not standing and singing God Bless America. Well, the person has a First Amendment right not to speak, not to sing, not to stand. The Yankees were sued over that. We don't need to talk about the outcome, but you just need to be aware that free speech issues, if there is state action, if there is a police presence, or if there is taxpayer money used to help build a stadium, First Amendment issues come into play, and people have a right to free speech, and that means the right to not say anything, or not to sing, or not to say the Pledge of Allegiance, or get up for the national anthem. All right, just because your security officers find it disrespectful Doesn't mean you can throw somebody out over it. Okay? That's pretty much it for today. For this section 2. Again, you need to be aware of the dram shop laws in your jurisdiction. You need to be aware of Fourth Amendment issues, First Amendment issues, especially if there are state action is involved. All right. Any questions? Please feel free to reach out. Thank you.